Start recording, because we do that these days. Actually, I want to make sure I'm recording to the right location. Yes, I am recording to the right location. And then we start streaming when it hits 11 o'clock. Stream in. Hello everyone, good morning, I'm Leonard French, your favorite copyright attorney, here with this week's law news and technology news and, well, you know what we do here, or if you don't, maybe I should go over it. Actually, I just realized my microphone is not near my face, so 1 second while I mute that so you don't get a big scratch. There, that should be just a tiny bit better, and maybe I'm a tiny bit clearer for you, and you can hear my deep, manly voice coming at you from Allentown, Pennsylvania. East Coast recently survived the nor'easter, 60-mile-an-hour winds, knocked everything around. Everybody has power, or everybody has no power for a week. Yours truly is fine, because I'm in a city. I'm not a city boy. I just live here because it's cheap.
Whoop whoop, city life.
But I've gotten used to the city. The city's nice. Can't complain about the city. I'm in between Philadelphia and New York City, only about an hour plus each way, or to each place, and can't really complain. It's not a bad place. It's kind of like living outside. Well, it's not as bad as living outside LA as far as like traffic and stuff, but you know, it's got like that suburban utopia feel to it. Suburbitopia. There we go. Coined a new phrase. You heard a new phrase here on Lawful Masses. Suburbitopia from Leonard French, your favorite copyright attorney. No, I thought that was fun.
Oh, that was pretty good.
Okay.
That was pretty good, man.
No, I was just kidding. I was just doing the self-deprecating.
Suburbitopia.
Suburbitopia. All right, well, that's the show. Have a good day, guys.
Right,
Thanks for coming.
Join us for the gaming stream.
Thank you for our March supporters and sponsors, our $50 plus supporters. No, kidding. All right, well, we have some great stories for you here today. If I can remember that they are stored in my browser and not on my notepad over here. Go over these real quick. We're going to talk about Martin Shkreli and his $7 million forfeiture and his, I think, 7 years in jail. We're going to talk about the Utah boobs that were sent out. Or, they might not be Utah boobs, but Utah sent out boobs. The Utah State Bar, the governing body for Utah lawyers, sent out their monthly disciplinary letter, or newsletter, or whatever. In Pennsylvania, we call it a disciplinary newsletter, so that's why I said that. Sent it out, and one of the images underneath one of the other images was a very pristine set of boobs. And I wanted to tell you more about this story, but Twitch and YouTube, I don't think, like the word boobs in titles, so we'll just talk about the story, and we won't actually be able to write, you know, hey, we're going to talk about boobs today on the show in the title, because they won't let us.
However, if you look hard enough, you will be able to find the story, so...
We will be giving you the link to the boobs. They're just, you know, they're nice boobs, but I mean, they're not like, this isn't like, you're not going to see anything new here, is what I'm trying to say. It's like, if you're hoping to be fulfilled by these boobs, they are very nice boobs, and they could be fulfilling, but they are no different or better than any other good set of boobs that I've seen.
Well, I mean, they were good enough for somebody at the Utah
They looked
Bar
healthy.
Association to
They
save
looked
on
very
their computer,
healthy.
right?
This
So-
person looked very healthy, let's just say that. We'll talk about the Clicker Heroes case. Clicker Heroes is being harassed by a patent troll for tokens, in-game tokens. I know what's going on, I think I know what's going on, but I don't even know, like, what this world has come to, that this is how people live their lives. Like, I don't know. If I woke up in the morning as a patent troll and I was like, let me get in my nice car and my nice house that was all paid for by writing a vague patent and then extorting people who don't feel like going to court against it, I don't know, I wouldn't really feel very good about myself. And I don't understand how people do feel fine doing that. I'm not saying this to be self-righteous either. It is a foreign concept for my brain to be like, you know that person over there on the street that's not quite as smart as you? Let's go find a way to get $5 out of them because they're stupid. Or worse, let's go find a way to get $5 out of them because they won't take you to court or won't call the police or won't know what to say. Or that just is so wrong. You're not making the world a better place. You've not made anything. You've not added anything to the world. Anyway, I digress. A 20-year-old has sued Dick's and Walmart over their new 21-year-old gun requirement. They won't sell guns to anyone under 21 years old, even if you meet all of the governmental requirements. And this 20-year-old has sued them, saying that that's not the way age discrimination laws work. In legal news, in law student and law school aptitude test news, the law school LSAC? I don't know what the A stands for. The LSAC is in charge of the law school aptitude test and Law School Aptitude Council? Law School Assessment Council? I'd have to look it up. The LSAC is in charge of administering the law school admissions tests, and they are being ordered and have been ordered in the past to provide better accommodations to disabled persons. And they really pulled a good one this time. They had an order in place requiring them to make certain accommodations for disabled people. And the way they were making these accommodations and trying to meet their statistics and all that was really underhanded. They would ask you a question, you would request an accommodation, they would deny your accommodation but offer a compromise, and then if you took the compromise, they would claim that you agreed to a full accommodation and it was not a compromised accommodation, among other things. The United States Patent and Trademark Office wants you to pay their fees even when they lose. This is basically a violation of the traditional American rule of who pays for a lawsuit. In some areas, the loser pays, but under the American rule, in most cases, the parties pay for their separate costs of their offense, defense, and litigation. They don't always, believe it or not, it's a kind of a myth that the loser always pays for the lawsuit. That doesn't happen the majority of the time. That only happens in copyright cases because we have a specific law that says that the courts can do that. And even then, that specific law, 17 U.S.C. 505, I think, only says the judge may or has the discretion to do that. So that doesn't answer our question. The USPTO thinks that when they lose, there's a law or something that requires the winner to pay certain expenses, and they are now expanding that to include all expenses, including their attorney's fees for the case. We're going to try and talk about a weird story. It's not that the story is like extreme or something, it's just 50-some pages long, and we're trying to summarize it in time. A couple lost foster care of some children when they refused to tell the children that the Easter Bunny is real.
Whoa.
Which just seems like a pseudo-religious thing on so many levels. Like, and what if it is an actual religious belief? Like, I personally don't believe in telling children lies about Santa Claus and the Easter Bunny. Certainly you can make a fun time for them without having to lie to them. I can't say that I was particularly jarred or anything by discovering that Santa was not real, but I have since discovered that there are lots of lies that adults tell children, and I don't think they're all particularly healthy. And I personally don't believe that the Easter Bunny and Santa Claus, as lies, are healthy. As fun, cultural participation things, absolutely. I'm not a downer. I'm really not a Debbie Downer on this one. I'm just saying I don't believe in selling children lies. I think we should be preparing children for what is an increasingly complex world and an increasingly marginalizing world. And I don't think that we have time, really, to play with children's trust. But you can judge me all you want. I don't have any kids of my own. I only have dogs. I do want kids someday, maybe, but, you know, that requires a lot of other things to be in place, like the resources and a partner and working plumbing and all that. So if all that stuff happens, great. But if it doesn't, I still think I have something to say on the issue. And I don't mean to speak out of turn. Matt Fury gave a Pepe license interview, or gave a interview that I'm calling the Pepe license interview, to Daily Dot a number of years ago, and we're going to go over it. A lot of you asked questions about the Pepe thing. I think I even have a script written. So, yeah, well, let me see if we can find this, our script for the thing. There's two oh, okay. Never mind. Outline and questions. Thank you. Let me look at this real quick. Oh, you have a whole bunch of questions in here. We might be going over lots of questions in the Pepe case.
Yeah,
we'll look through this.
Yeah, some of the because there were a lot of repeat questions, I sort of grouped the questions and comments together into themes, and then thought that you could discuss the themes in terms of basically using Pepe as an example to explain the basics of copyright, because there was a lot of misconceptions.
A Kansas Secretary of State has been rebuked by the judge, and we'll go over what the ACLU says about the case and a few finer points from this lunacy. Trump is in court for blocking people on Twitter, and the judge has come up with quite a normal solution that honestly highlights how stupid this whole thing is. And I mean stupid on all... there's one party that's behaving stupider than the others, but, you know, I'm not here to get down on Donald Trump. I'm here to talk about the legal rights of people and why he's not allowed to just block people on Twitter. The cop, there's an update. The cop who told the Uber driving lawyer not to film, and that there was a new state law that said no filming, well, that cop was demoted, but he appealed. He was reinstated, and then he suddenly resigned. And we'll just talk about the story, and it's an update. It's a lawyer, Uber driver, you remember it was like a year ago. And then finally, I don't know if we're going to cover this one, guys. You can tell me, but this was one of the things that, that came up this week. Florida finally changed a law that allowed 11-year-old to be forced to marry her rapist. Among other egregious marriage violations that I would say. I would call them violations, because marriage is sacrosanct, is sacred. Honestly, even if you're religious, and I was raised religious and I married religious before I decided that I did not believe many of those things. But I'm not getting down on religion. I'm saying that I don't think it is within many religious beliefs to take advantage of a young girl or boy and marry them, usually a girl, if I understand the situations correctly, but to marry them at 11 or 14 or 15 years old. Even 16's a bit young, 17's not even an adult, 18 you still can't even drink, 21 you can finally drink, but your brain doesn't even stop developing till you're 25, and you're not fully emotionally developed until sometime in your mid-20s to mid-30s. So And that's if things are happening normally for you. If things are being developmentally delayed by a physical or mental condition or trauma or something like that, it can take more years if you're getting treatment. So let's not assume that 11-year-olds can consent to marriage, people. I mean, what the heck? Even 14 or 15-year-olds can't consent to marriage. I married a young girl when she was 18, and that wasn't a good idea either. She didn't know what she wanted. She didn't want me. She just wanted to have a good time. There's TMI for you. Okay. Welcome, 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 everyone. I am Leonard French, your favorite copyright attorney. Let's start with some of our first stories here. Oh, that means I gotta take the music out, too. Let's do that again. Alright, this one, we'll start with the Martin Shkreli story. Sorry, one second. I've got too many windows open, is what's happening. And I can't keep track of all of it. That's the March 5th one. I don't want the March 5th one. I want the March 9th one. There we go. Thank you. Okay. So you may remember our friend Martin Shkreli. Well, it turns out that Martin Shkreli has a couple things going for him these days. First, he is being ordered to turn over $7 million in property. Whereas on June 3rd, 2016, Martin Shkreli was charged in a superseding indictment with multiple counts of conspiracy to commit securities fraud, conspiracy to commit wire fraud, securities fraud, and wire fraud. Whereas the indictment included a forfeiture allegation seeking, pursuant to various laws, the forfeiture of any and all property constituting or derived from proceeds obtained directly or indirectly as a result of the commission of any of the charged offenses. Whereas on July 26th, the defendant and the government stipulated to waive any right to have a jury determine the forfeiture. Whereas on August 4th, 2017, a jury found the defendant guilty of count 3, a jury found the defendant guilty of count 3, securities fraud involving MSMB Capital, count 6, securities fraud involving MSMB Healthcare, and count 8, conspiracy to commit securities fraud involving Retrofin Unrestricted Securities, herein the offenses. Whereas, based on the submission of the parties and the proceedings herein, the court finds that the defendant must forfeit to the United States the amount of $7,360,450, which amount represents the total amount of proceeds obtained by the defendant as a result of the offenses. Therefore, it is adjudged the forfeiture money judgment is entered. All payments must be made by money order, certified, or official bank check payable to United States Marshals Service. The defendant shall cause checks to be sent by overnight mail. The entry and payment of the forfeiture money judgment is not to be considered payment of a fine, penalty, or restitution loss or amount of payment of any income taxes that may be due and shall survive bankruptcy. Finding that the conditions for forfeiture of the substitute assets have been met, the defendant shall forfeit his interest in the following assets, as well as all proceeds traceable thereto, up to the amount of the forfeiture money judgment. $5 million in cash that is currently held in an E-Trade brokerage account via Viera Pharmaceuticals, formerly known as Turing Pharmaceuticals, the album Once Upon a Time in Shaolin by the Wu-Tang Clan, the album The Carter 5 by Lil Wayne, and a Picasso painting. Upon forfeiture of the substitute assets and following the resolution of any third-party claims, the value of the forfeited substitute assets shall be applied towards the satisfaction of the forfeiture money judgment. Subject to the terms contained herein, the United States Attorney General or his designee is authorized to seize the assets and any proceeds traceable thereto, or any proceeds traceable thereto, to collect the money judgment in according with Federal Rule of Criminal Procedure 32.2, B3 and C. Can conduct any paper discovery, commence any applicable proceeding to comply with the statutes governing third-party rights, including providing requisite notice of this order and the forfeiture of the substitute assets. The United States shall publish this order on forfeiture.gov. Any person who has a legal interest in the substitute assets may file a notice within 30 days asking the court for a hearing without a jury to adjudicate the validity of their interest in the property and for an amendment of the forfeiture. The government may seek an amendment of the forfeiture and in order to preserve the value of the substitute assets and ensure that the forfeiture money judgment is not diminished, damaged, or dissipated pending any appeal, neither the defendant nor anyone acting on his behalf shall take any action that would have the effect of diminishing, damaging, or dissipating the substitute assets. The execution of this order and the seizure of the assets shall be stayed pending the final disposition of any appeal. The substitute asset list in paragraph 4A above shall remain on deposit with the clerk of court. Within 10 days of the date of entry of this order, the defendant shall provide an accounting of his interest of the substitute asset list. Within 10 days of this order, the defendant shall advise the government of the location of the substitute assets, specifically the albums and the artwork. The defendant must obtain the government's approval as to where and how the albums and artwork are maintained and, if necessary, transported during the pendency of any appeal. Further, the defendant shall allow the government to inspect the albums and artwork at any time. The defendant, his heirs, assigns, agents, representatives, attorneys, and anyone authorized or acting on his behalf, as well as any persons or entities acting in concert, are restrained, enjoined, and prohibited from taking any action that would affect the availability, marketability, or value of the assets. Further, the defendant and his representatives shall take reasonable steps and bear the costs necessary to ensure that all the substitute assets are preserved and maintained in good and marketable condition, not damaged, diluted, or diminished in value. Any income or compensation accruing from any of the substitute assets, including but not limited to any consideration for defendant's interest in Viera Pharmaceuticals, shall be placed in a designated interest-bearing escrow account so that it may be made available for forfeiture. Defendant shall provide the government with any accounting. Further, the defendant shall provide the government with an accounting of any income or compensation within 10 days of the date received. The defendant and his representatives shall not directly or indirectly transfer, assign, pledge, waste, hypothecate, distribute, dissipate, dilute, or remove from the court's jurisdiction any assets. He can obtain the government's approval, is what the rest of that paragraph means. In the event that the defendant pays the forfeiture money judgment in full, or the defendant, pursuant to subparagraphs 1E or F above, sets aside enough funds to satisfy forfeiture money judgment, and no third-party claim is asserted, such judgment and the remaining restraints on the substitute assets set forth in this order shall be vacated. In the event that the defendant fails to comply with any of the terms in paragraphs 10 through 12 above, the government may seize the substitute assets up to the amount of the forfeiture money judgment, notwithstanding the pendency of any appeal. This order shall become final as to the defendant at the time of sentencing and shall be made part of the defendant's sentence and included in the judgment of conviction. This court shall retain jurisdiction, and the clerk of court is directed to send 3 certified copies of this order to the U.S. District Attorney, the U.S. Attorney's Office, and same person. Okay, to the Assistant U.S. Attorney's Office. I'll just do this over. The clerk of court is directed to send by interoffice mail 3 copies of the executed order to the Assistant U.S. Attorney's Office. Signed, Judge Kiyu Matsumoto, U.S. District Court, Eastern District of New York. So that's only the first part of this, because we're not quite done with his judgment. Now, the judge doesn't release like a judgment document, so I'm just going to be pulling facts from various other sources. On Friday, Martin Shkreli was sentenced to 7 years in prison in addition to all of that forfeiture. In handing down the term, the judge cited that Shkreli had asked to minimize his conduct, asking for no more than 18 months, and she believed that that was not appropriate. The opposing side, the prosecutors, had asked for 15 years, and they felt that that was appropriate given the grave mistakes and poor judgment that he conceded in tears at his sentencing hearing to the judge on Friday. The only person to blame for me being here is me. There's no conspiracy to take down Martin Shkreli. I took down Martin Shkreli, Martin Shkreli said. No one else is to blame, not the court, not the government, not the media. Prosecutors said he lied to investors in his MSMB capital and healthcare hedge funds about the hedge fund's size and performance. He used sham agreements for cash and stock of Retrofin to pay off the aggrieved stakeholders. Retrofin's another company he owned or ran. He also used a network of associates in an unlawful attempt to control Retrofin's stock price. He was convicted in August of securities fraud and conspiracy. He was acquitted of 5 other counts. They sought a term of at least 15 years, citing his 5-year scheme where he called himself the Pharma Bro and repeatedly lied to investors. He did not spend his victims' money on lavish trappings. He did steal money for his own personal benefit. It was his image as a successful businessman and entrepreneur that mattered most to him. A lot of the rest of this article is very well researched and is probably not fair use for me to read. In addition to his prison term, he was fined $75,000. He has to forfeit more than $7.3 million, including the album that we talked about. This is approximately 10% of his net worth, if I understand it correctly. I don't know who measures that or whether that's accurate or not, but so this is not the end of Martin Shkreli. This is just a major punishment for a fairly major crime. I'd still like to point out that people who have committed violent crimes have gotten far worse for what would seem to be far less in damage, but, you know, those are violent crimes. And then some people who have committed some not violent crimes have still gotten far worse. So it still feels a little unfair that he only got 7 years while other people are getting worse for what some people consider lesser crimes. But that's all up for debate. I'm not claiming to be an authority on who should be punished and how. It could certainly be up for debate. But it does seem to be a little bit lenient for such a potentially damaging crime. But 7 years is still 7 years. If I understand federal sentencing correctly, he will serve at least 85% of that. And 85% of 7 years is somewhere around 6+ years. So he's going to be in prison, an actual federal prison, for 6+ years. So, nice. What do we think of that? Any thoughts, questions?
No questions submitted at all, actually. Guys, remember you can submit questions by typing !ask and then type it in your question in the chat. But that's a very interesting case there. And the sentencing is... I don't know, what do you think? Do you think that that's justified, or...?
Well, the sentence is definitely justified. Well, first off, like, let me be a little bit biased here. It's always a little bit worse to commit criminal acts against rich people than poor people in our American culture. It's much more likely that a wealthy person will have the resources to go after you, including being able to sway the police department. I've seen this with my own eyes. I've been in court against a prosecutor who literally did this, so I'm not speaking out of turn here. This does happen. So some people have said it this way: his major crime was defrauding rich people, not just poor people. In other words, nobody prosecuted him when he raised the price of whatever the medication was by like 1,000%. It was some terrible multiple. It was a lot of money that people had to spend who don't have money because they have a medical condition and they're paying for it. So now they have even less money to pay for their medical condition. There was no crime there apparently, but there was a crime when he lied to investors. Okay, fine. So they got him on that. And what you could say is that he got himself on the Fed's radar by being such a jerk to the people with the pharmaceutical companies in the first place. So yes, it does come full circle. People do notice you when you're a jerk in general. So if he's being a jerk and he's doing stuff that could be potentially illegal, that's violating the one crime at a time law, basically. Attorneys have this rule, commit one crime at a time, and I'm not encouraging anyone to commit a crime, but in the philosophical sense that we're all criminals, you want to commit as few crimes as possible to be within the discretion of the prosecutor as little as possible. So if you're driving a car that has a tail light out, don't be hauling anything illegal. If you are hauling something illegal, don't be driving a car with a tail light out, giving the prosecutor, or in this case the police, the prosecuting authority, the discretion to pull you over and take you one step closer to finding the other crime. Also, lawyers will tell you that sometimes you don't know you're committing a crime. Maybe your friend left a bag of drugs in your car or left a knife in your car. I had the knife thing happen to me once. And you go someplace where that knife is illegal or those drugs are illegal. Maybe you're allowed to have a sealed bag, or maybe you're allowed to have a container of alcohol in your car in one place, but you're not allowed to have a container of alcohol in your car in another place. Something like that. And you go and you don't realize it. We have this happen here at the Pennsylvania-New Jersey border when law-abiding Pennsylvania citizens bring their perfectly lawful and locked and closed firearm into New Jersey, and New Jersey arrests them and puts them into jail for having a loaded weapon, even though the weapon was locked, with no bullet in the chamber and and a lock through its magazine and feeding mechanism. So the chamber is open, the slide is locked back, the thing's in a container, and the bullets are somewhere else. But the way New Jersey has written its law is you can often find those parts are considered within the same container, and the law considers the weapon loaded even though the bullets are not anywhere physically in it, or even able to be put in it without considerable effort and time. The law still considers you to have a loaded weapon. So these people get arrested. So that's why we tell you commit as few crimes as possible at a time. If that person had not been pulled over for something else, there would be no way that they would have been arrested for having a locked and unloaded weapon in their car that New Jersey law still considers loaded and illegal. So, small rant. Sorry about that. This is going to be a long show. Holy crap. We're not going to get through
No
this.
worries. In regards to the case itself, I know that my mom was actually on Daraprim, which is the drug that was increased in price, because she has Crohn's disease, and the infusions...
Oh, my ex had
yeah. The infusions that they give to people with Crohn's disease actually decrease their immune system by quite a lot. So they were giving her Daraprim to prevent certain kinds of pneumonia. And she was on it because... obviously she needed it.
So it's not like first off, it's not like a cosmetic medication where it just like makes you feel better or something, which would be like a, illegal drug or something that people would, but it's not like a secondary drug where it's like to help manage symptoms or something like that. It's an actual life-saving drug to help boost your immune system during a time when your immune system is susceptible to life-threatening diseases and infections.
Yeah, it's also used to treat parasites
too. What a freaking scumbag.
Yeah, it's used to treat parasites too.
If anything, I would be working my life I would be doing everything I could to make the drug more affordable for people. Oh my goodness.
Yeah, it's used for people with AIDS as well, yeah.
Scumbag.
And it's also used to treat certain kinds of parasites that can get in your body. So, yeah.
I really have a problem with human beings who don't want to add anything to the world and just want to take from what's existing and not give anything back. I just don't. It would be akin to burning fossil fuels for fun. Like,
Yeah.
it's one thing if you're burning gas in your car to get to the post office, to get the letter that you need to respond to so that your client can do their thing in court. Or if you use the gas in your car to go to the store to buy groceries, so you can then go to the other store, and have food that, you have fuel to go to the store and buy, like, let's say a woodworking project or a metalworking project or an art easel or a computer to type your words on the internet, whatever. As you're doing something with it to make the world a better place, even if not every single thing you do is to make the world a better place. That's sort of my own high personal standard, is I want to make the world a better place with pretty much everything that I do. And I don't mean like I'm making some huge difference. I just mean incrementally. I just mean that, like, positive effort. This is Sisyphus pushing the rock up the hill and trying his best not to let it roll back down again. So yes, I realize the futility of what I'm doing, hence the Sisyphus analogy. But, I'm the stubborn jerk who's going to keep pushing forward, whether it works or not, because one of these times it's going to work. One of these times things are going to align. We'll create a standing wave of people in some kind of not proletariat revolution, because I think that's just a little bit of a fantasy, Marx, but something along those lines, some kind of non-violent but still changing revolution, force-altering or life-changing revolution of people who well, we're already here in the Creators' Revolution. I was reading books about this 15 years ago that were telling me this was coming, and if I wanted to be part of it, I better start doing it now, 15 years ago. And here I am, a little bit behind, but we're catching up, and this is really awesome. You guys are really cool.
So cool. That wasn't a very good contribution. I apologize.
So real quick, which we're going to try to remember to just remind people of ads and things like that, because this is a sponsor-supported channel. So thank you real quick to my Patreon supporters and my Twitch subscribers, and my other subscribers and supporters. I think we have sponsus.org/u/law or something that Cerulean is working on. But what I want to talk about real quick here is audible.com. We have audibletrial.com/lawfulmasses. If I can post this link in chat here. If you are not an Audible subscriber and you want to listen to audiobooks, or if you just like books in general, I've been listening to a great book here. I'll get this up on screen. This is Logically Fallacious, over 300 logical fallacies. The book is several hours long. I forget. Does it say here? The book is several hours long, and his reading of it is good. It's read by the author himself, and they go into over 300 logical fallacies. They go into over 300 logical fallacies, and I'm studying this right now because we want to start doing a series on logical fallacies where every week we'll bring you a logical fallacy and we'll talk about it and we'll give you some examples and then move on. This week I don't have one for you. I'm not that prepared. I didn't think that far ahead. As far as I thought ahead was advertising this to you. So we get a $15 commission when you try the Audible. When you do an Audible trial. No, I don't want anybody to sign up just because you want to get me $15. I want you to sign up only if you really want to try Audible. But it is a very nice program. It helps just support our channel a little bit. Buys the dog food, basically. Last month it paid for the dog food, so that was great. So, moving on. I keep losing my stories. Keep moving my screen. Stop it. There's my
thanks to Daichi Luazura for the 15 bits. Thank you for the 15 bits. Thanks to Get Depantsed and Blackleaf 31 and Kyoryu Hunter for subscribing on Twitch.
So this next story is a bit lighter. The Utah State Bar, the office that licenses attorneys in Utah, the officials are horrified after sending out an email blast on Monday that included a photo of a topless woman. The message was sent to all active Utah lawyers and was intended to promote the bar's spring convention. The email included photos of a clothed Lady Justice statue and a rock formation, and then below that was a picture of a very naked top half of a woman. The bar followed the email about 20 minutes later with an apology. Apparently, we have sent an email that is offensive. Apparently, we have sent an email that has an offensive image in it. We deeply apologize for this and are investigating the cause. The communications director said he will get to the bottom of what happened and ensure it never happens again. We are aware of it and we are horrified, he says. And if you would like to see the picture of boobs that I promised, here is the Above the Law article on it. And there is a very, well, depending upon your country, I would consider it a very PG-13 or PG-rated boobs picture. But if you're in America, it's nearly NC-17 or R-rated to show boobs in many places. So, although to be clear, the state of Pennsylvania, if I understand it correctly, and the city of New York City recognizes that boobs are not automatically sexual, and there is a First Amendment right in going topless for both men and women. So you can go topless in New York City, if I understand it correctly. You'd still want to verify this, and you'd also want to verify this other one because I haven't verified it myself. I believe you can go topless in Pennsylvania, but someone would want to look that one up first before they get charged with something. And none of this is a guarantee that you won't get harassed. So you could very well get harassed, including arrested, if the wrong police officer thinks that they have the right to do so. So, you know, but that's always the risk with enforcing your rights, or what's the word? You're not enforcing your rights. You're exercising your rights. That's always the risk with exercising your rights, is that you'll offend someone and they'll call the police, and the police might agree. And if the police agree and they're wrong, well, you don't beat the ride. You beat the time, but you don't beat the ride. So you still get to have that experience of riding in the back of a police car wearing handcuffs and all that. And it's very embarrassing, and you can sue the police for a civil rights violation, but it's not always a civil rights violation, and the police don't always give you money for that. So it's a shitty world sometimes. Good luck. You don't need an ad break after that. Okay, let's talk about this. You guys have been asking about this for the last week. We, Playsaurus, developers of Clicker Heroes and Clicker Heroes 2, are getting shaken down by patent trolls for using virtual currency in our game. GTX Corp, owners of patent 7177838, claims that we're infringing on their patent for using electronic tokens. They assume they mean rubies. They are offering to let us pay a bargain $35,000 license fee to avoid costly litigation. We were given 10 days to respond. I believe their claims are completely meritless and their behavior to be abusive and terribly unethical. As I am a major owner of Playsaurus, I see this as a personal attack, and the cost in my time and well-being has already been significant and draining. It is a shame that these United States legal systems Wow. It is a shame that the United States legal system can't provide a quick and easy way for us to punish them for these actions. I believe it is unethical on our part to pay any negotiated amount which serves to encourage the behavior of trolls with bogus claims. So if pressed, I will take the matter to court and see it to the end. We have retained a law firm to assist and represent us if necessary. Playsaurus is a 100% privately owned organization, and we are not beholden to outside investors. We absolutely refuse to negotiate license fees with patent holders who make bogus claims. You can see everything in the PDFs below. I have included our response, written by my good friend Miguel Bombach. I have included our response written by my good friend Miguel Bombach from Perkins Coie, describing to GTX how their claims are completely meritless. The history of the patent is long. It was used by several different companies who owned it to shake down countless major institutions about 10 years ago. I remember this. A more recent development is that they are threatening smaller companies who typically don't have the resources to defend themselves. What they're asking for is $35,000, about half a year's salaries for one of our employees. About half a year's salary for one of our employees. I am concerned they may be preying on a lot of other small studios in a final attempt for them to profit off this bogus patent, which has about 2 years left on it. I believe they are targeting smaller organizations now because recent developments in patent law have made bogus patents like these much easier to fight, but only if you have the resources and money to properly prepare the legal challenge. If they were to go after larger organizations, the patent could be easily challenged, but smaller orgs like ours can't afford to go through that process easily. Their letter to us looks like this. Law firm represents GTX Corp., facilitating acquisition of electronic tokens by consumers, payment platform, violation of intellectual property rights, $35,000. Then they have a patent here. The patent is for methods and apparatus for conducting electronic commerce using electronic tokens. The electronic tokens are issued and maintained by a vendor which also provides products and services that can be purchased or rented using the electronic tokens. This is from like a kind of a, not a movement, it's horrible, but it's from an era about 10, 15 years ago where when the internet got started, there were a whole bunch of like methods patents, procedure patents, like we're going to do the same thing we've always done in commerce, but now we're going to do it on the internet, and we're going to patent that as a completely new and novel process. It was not novel, but patents are not granted that way. Patents are evaluated for whether they meet certain requirements, and then the applications are granted. I don't know all of the details. Some patent attorney like Blackleaf could go into it more. But the point is, some of these patents were granted prematurely or while they're a little bit too broad. And so companies who own these patents can send them to basically defendants, to smaller victims, and they can assert their alleged rights and say, look, if you don't pay us a relatively small amount of money, then we will go to court over this patent, and you won't be able to defend yourself, and you'll lose more than a small amount of money defending yourself, even if you win. So just pay up. And they've done it as a cease and desist, or excuse me, as a demand letter. They've done it as a demand letter this time instead of as a lawsuit, so they're not even open to a counterclaim. Playsaurus would still have to go to court against them in a separate proceeding. This is just the demand letter section. So this company is hoping that the lawsuit won't have to be filed. However, they are still threatening it because they've already drafted it. This is something that I've done as a plaintiff's attorney, is you draft the lawsuit and claim that it's ready to go. The trouble with doing this is that you've now shown your hand, and I can start preparing defense documents before it's ever filed. I have extra time to respond. Great. So their response, I think, is probably what we should go over. Dear Mr. Jacobs, this is coming from Miguel Bombich at Perkins Coy. I write in response to your letter to Playsaurus. Clicker Heroes does not infringe your patent claim, nor are the patent claims valid. Your letter includes many false assumptions. Your claim of the 838 patent is directed towards a server, Clicker Heroes. In contrast, the claims of the 838 patent are directed towards a server. Clicker Heroes, in contrast, is client software. Your letter emphasizes the alleged novelty of the server and its applicability to the claims in many instances, and your allegations assume that Playsaurus operates a server that performs the recited routines of Claim 27. Upon information and belief, the Playsaurus server includes a computer having at least one processor that executes software stored in a memory, the software including one or more programmed routines. But this assumption is incorrect, and the 838 patent is clearly not infringed. Claim elements directed to server routines cannot be satisfied by client software. This is most evident in Exhibit B of your letter. Paragraph 36 illustrates the sale of rubies, but the software that allows the sale is client-side. The claim also requires that the server maintain a database entry that emphasizes and emphasizes that the only manifestation of the tokens is the database entry. Clicker Heroes, however, stores rubies on the client device. PlaySource does not track users' rubies, nor does it track how users spend their rubies. For this same reason, Clicker Heroes cannot practice any of the claim selection authorizing purchasing routines, any theoretical selection authorization purchasing of an item using a ruby is done by the client. Any theoretical selection, authorization, or purchase of an item is done by the client. Further, paragraph 37 illustrates a display of various items, but again, this is client-side. Your allegations are baseless. The claims of the 838 patent are directed to something entirely different than Clicker Heroes. The fact that Clicker Heroes operates client-side can easily be verified, and then explains how. Beyond your server, there are many other differences between the claims and Clicker Heroes. The claims of the 838 patent require a selection of a subset of products. Clicker Heroes, in contrast, does not download items after selection. The previous discussion of non-infringement should in no way be seen by you that the 838 patent is valid. It is not. In fact, the 838 patent is a perfect example of a patent that is subject to ineligibility under 35 U.S.C. 101. The 838 patent recites an abstract idea, issuing tokens to be used in purchases applied to the internet and computers. See Alice Corp. versus CLS Bank. Invalidating claims directed to claims that recite the abstract idea of an intermediated settlement using some generic computers. This abstract idea is no different than using tickets to purchase drinks at a party or going to an arcade using tokens to play games. Beyond Alice, the claims of the 838 patent... Wow, I'm doing great this morning. Beyond Alice, the 838... One second. Beyond Alice, the claims of the 838 patent are invalid in light of prior art. The use of tokens to purchase in-game assets is not a new thing and is a well-recognized tool employed by game developers for decades. One of the most recognizable games is Neopets, which was launched prior to the filing of the provisional application of the 838 patent. In Neopets, users could buy and use Neocash within the game. This is clearly the same idea you have claimed to have invented with the 838 patent. Beyond games, the concepts described were well known and discussed in printed publications. It is very noteworthy that a continuation of the 838 patent, which shares the same disclosure and substantively similar claims, was abandoned by the inventor after a USPTO rejection. The USPTO felt that some of these references taught at least some of the below limitations. Issuing a plurality of electronic tokens from a micropayment service provider server of a micropayment service provider. What? I can't even read this myself. Issuing a plurality of electronic tokens from a micropayment service provider server of a micropayment service provider to a user device suitable for use in micropayment transactions. Providing a plurality of micropayment user account at... What is this? Providing a plurality of micropayment user account. A plurality without words that are plural? Rah! Providing a plurality of micropayment user account at the micropayment service provider server to the user, each micropayment user account in the plurality of micropayment accounts. See there, it is accounts. It is a typo. Okay, I'm not nuts. I thought I was freaking nuts. I'm trying to figure out how this could be plural when there's no plural in the sentence.
Brain hurts a little bit.
It's not. It's got to be. Highly technical language is really hard to read sometimes. providing a plurality of micropayment user accounts at the micropayment service provider server to the user, each micropayment user account in the plurality of micropayment accounts storing a subset of electronic tokens purchased with a different currency. Providing more micropayment stuff that we're not going to read because it's just super technical. Rather than providing substantive argument in response, the inventor appears to have conceded that his alleged invention was not novel in abandoning the 420 patent. These ideas are the same that you claim to have invented in the 838 patent. Neither of the patents were before the USPTO when it was examining the 838 patent, and it would not have issued had the USPTO been aware of them. We also believe that all mobile game developers are already licensed to the 838 patent. The 838 patent has been previously asserted against Apple and Google, and these cases appear to have reached settlement in 2009. You cannot now take that same patent and a decade later try to extract more money against developers who list their games on the Apple and Google store. Your attempt at double dipping is inappropriate. For all the reasons above, should my client need to defend itself on such a meritless claim, we will seek attorney's fees. Sincerely, Miguel Bombich. I apologize for my poor reading of that. I don't know what's going on. So that's really interesting. So that shows that Playsaurus has some teeth, and they're ready to go to court against GTX Corp. And they want to make clear that GTX Corp is not the same as other GTX Corps. There are multiple companies that go by the name GTX Corp. They think the trolls are GTX.com. That's their final word on that. So what do we think of that? Holy mackerel.
I think I don't really understand what was just said.
Yeah, so let me try and summarize, because I actually think I understand what's going on here. What happened back in the early 2000s was, I said this before, but I'm going to try and summarize this again. What happened back in the early 2000s was a bunch of companies, people, patented things that weren't necessarily patentable. The internet was new, and doing things on the internet sounded novel, it sounded new, and patent examiners are just lawyers, and lawyers are known for not always being technologically savvy. It's kind of a thing. It's actually kind of weird to find a tech-savvy lawyer, even these days. It's not that it's weird, it's just many lawyers are so focused on the law and their careers and their jobs and stuff that they don't have time to become super tech-savvy. You know, leave that to the tech-savvy people. You know, that's a niche now. So these patents would get granted because how is a lawyer, a patent examiner... You know, we're also not talking about like star litigators here. I'm sure that it's remarkable that Albert Einstein was a patent examiner and all that, but it's not like you have the top attorneys lining up to work for the USPTO. Maybe to lead it or something, but I don't know that they line up to work as patent examiners. And I'm certainly not trying to talk down about patent examining. It's probably a really great job, stable government position and all that. I just mean that you can't expect the attorney who is doing the patent examining to just be like some kind of god in knowing everything about technology. I'm defending them a little bit. So they issued the patent, which was bad enough, but let's just get past it. They issued the patent. The patent is a bit abstract. It just says tokens can be substituted for money, and then those tokens can be used to buy things in game or in a server client side arrangement. And Clicker Heroes certainly has to be some kind of server client side whatever, right? Because the game has to talk to a server to exchange the money, right? The money, somebody has to verify that a credit card number got entered or something. And that's usually what? The Apple Store or the Google Store, right? So what this company is saying, what GTX Corp is saying, is that they have a patent on microtransactions in the Apple or Google Play Store or something similar. And that since Clicker Heroes uses the Apple or Google Store, or since they were accused of just no evidence, just flat out accused of having some third-party server process the transaction, which I believe is a violation of the Apple and Google Store terms. But this company is saying that they have the patent on those microtransactions, and that anyone who's doing microtransactions, which is really anyone doing microtransactions, would be subject to their patent. Now, as you saw in their response, the patent is probably invalid, one, because it's it's a patent on an abstract process. It's not a patent on some specific, repeatable process. Go here, do this, use a gear this size. Excuse me. It's not a specific process. Use parts this size, put them together this way, and when you spin it this way, it'll work this way. It's not specific enough. It's an abstract process. Have somebody buy a token with their real money. That token becomes an in-game currency. Then they can buy items in games. That's not a patentable idea. That's an idea, but that's not a patentable idea. So the Clicker Hero's response was really well written, in that it addressed both the fact that the patent itself, even if it is valid, doesn't address the Clicker Hero's model, that the patent is probably invalid under the new Alice standard, and that Apple and Google did pay licensing fees to this company, shame on Apple and Google, and therefore those licensing fees cover everything on the Apple and Google store. It wasn't just Apple and Google that had that. Those licensing fees actually covered the products that they were selling as well. So they're trying to say that the GTX Corp claim is double dipping by requesting a licensing fee from a company that is selling things through somebody who already paid a licensing fee. Get it? So does that make more sense now? Does that make it more understandable?
Yeah, a little bit.
Any further points of clarification or questions that you'd like to get out?
Not from me. I'm checking the questions list really quick, but if there's anything else you want to say.
Let's see. Blackleaf says, Alice, where are you?
I have the question here.
The vast majority of patent examiners are not lawyers. Examiners all have technical degrees, but legal degrees are rare. You can find a patent attorney without being an attorney, strangely enough. They call them agents instead of attorneys, but there is no difference. Alice and the many, many cases that followed it is a legal nightmare that they are still trying to resolve. This is Blackleaf's life on a daily basis. It is very unwelcome. Like a jealous mistress.
Question from Manitoban
Misanthrope.
Yeah, it goes off the screen on my end. Could the patent be challenged?
The patent could be challenged. So anyone who's using a process that could be licensed under this patent or claimed under this patent can challenge, even preemptively, I believe. You'd have to talk to your attorney about standing, but if you have either an inevitable claim, this sort of thing would put you on notice that they could claim something at any time, then you'd be able to preemptively sue them. Or if they sued you, you'd be able to make a counterclaim claiming the invalidity of their patent. And then the burden of proof is on you, though. You have to follow a legal standard for proving that their patent is invalid. And it's very expensive. It involves a legal challenge, it involves expert witnesses, and it involves patents. All three things multiply money by a lot. So, good luck. Excuse me.
A question from Darzoni. Does the specificity requirement for patents mean that it's hard to patent things like software algorithms?
Yes, there's a standard. If it's too abstract, then it will not be patentable. And if it's specific enough, then it will be patentable. I'm not a patent attorney. I don't know this standard beyond that. But the basic patent standard is that a Patent has to address something that is new and not easily guessed or not easily arrived at by a professional normally trained in the field. The field of study, the industry, whatever that is. So in this case, a person who is normally trained on microtransactions and the internet would have figured out microtransactions and the internet. A person who is normally trained on using tokens or tickets or something in order to exchange real money for fake money so that something can be purchased separately, that's not new and novel to a professional trained in the field.
Question from...
Any other questions?
Yeah. Question from Sigen LH? Something like that.
It is an L. I thought it was
yeah. I'm going to paraphrase it a little bit. Are copyrights more powerful than patents in your opinion? Which is the more powerful form of protection, do you think?
It doesn't work like that. They aren't two forms of protection that cover the same thing. So their power cannot be measured.
So it's apples and oranges.
Like that. That's a false equivalency. Yeah, they are not equivalents. Patent covers functional ideas that can be made public. Trade secrets covers functional ideas that can't be made public, that say are too abstract or aren't patentable. Trademark covers business branding and source of goods, and copyright covers creative works of expression, not functional works. The design of a functional work can be copyrighted, but the actual functionality is patented. So you can't copyright a car engine. You could copyright the non-functional pattern in which you machined the heatsink fins. But if it's proven that that machining was done for functionality to increase surface area or something, as opposed to purely cosmetic reasons, then it's a patent and it will not be copyrightable. So, for example, the road signs that have the little springs on the bottom. Company tried to say that those springs were part of its trade design or its copyright or its patent. And the courts finally said that no, you can't trademark it because it's functional. No, you can't copyright it because it's functional. And yes, you could patent it, and there were reasons why that wasn't covered under patent, separate. So it's not that copyright is more or less powerful. They're just different. They're just used for different things. You'll definitely see some overlap, but overlap is not necessarily welcome. Omega Watches, was it? Tried to limit re-importation of watches based on copyrights by putting a copyrighted design on the back of the watch and then saying that Costco was importing illegal copyrights. No, they were importing watches. Watches which are perfectly allowed to be imported under import laws. And they're not importing copyrighted works that are allowed to be restricted under import laws.
I think there was a lot of technicality to this reading, and it's definitely...
Well, yeah. Do you understand why we do less patents on this show? They're really... You think that opinion of that judge in the copyright case last week was technical? Oh my god. The patent stuff is always like that. We were going over the First Amendment stuff in that whichever case that was. Crap, I forget which one. Everybody was so confused by the heavy language in the one we just did Friday. My mind has gone blank. The Zombie Go Boom case. It's so heavy on the contract interpretation language, but how else are you supposed to explain it?
Can I read some cheer and subscriptions really quick?
Yes, please go for it.
Alrighty. We have a tip from Yasuki Humai. Tipped $5.12. It just said, "Good morning."
Oh, thank you very much.
Absolutely. Whiskers is. Oh, I'm accepting the thanks on her behalf, but I'm guessing that would be the response. Whiskers cheered 50 bits, saying, "Woohoo, made it."
Yay, Whiskers.
Kyoya Hunter also cheered 100 bits as well as a subscription, saying, "Hoping to be fulfilled. Unsure what they want to be fulfilled about, but thanks for the bits for sure." And a subscription from BDG as well, 1 month subscription.
Very nice. Let's see, where are we? Let's go to this one. So this happened. In light of recent events, we've taken an opportunity to review our policy on firearms sales. Going forward, Walmart is raising the age restriction for the purchasing of firearms and ammunition to 21 years. I believe Dick's Sporting Goods did something similar. Well, it has earned them a lawsuit. Tyler Watson has alleged unlawful age discrimination in violation of Oregon state anti-discrimination law. Plaintiff entered a Walmart during normal business hours for the purpose of buying a rifle. Plaintiff went to the firearms section and told the clerk that he wanted to purchase a rifle. Plaintiff told the clerk that he was 20 years old. The employee told plaintiff they would not sell him any firearm, including rifles, shotguns, ammunition, because he is under 21. Defendant's employee specifically stated that it is defendant's new policy not to sell any firearms or ammunition to anyone under 21. Defendant left the store without purchasing a rifle. By denying plaintiff the sale of a rifle and or ammunition based on plaintiff's age, defendant has committed illegal age discrimination in public accommodations in violation of Oregon Statute 659A 403. In addition, defendant has publicly advertised its unlawful discriminatory policies by issuing a press release, we just read, among other materials, stating that defendant will no longer sell firearms or ammunition to any person under 21. This is a violation of that same section 409. Then, pursuant to 659A 885-7, plaintiff asks the court for injunctive relief, ordering it to stop unlawfully discriminating against 18, 19, and 20-year-old customers in Oregon locations, and to give punitive damages in an amount that will be determined because of the willful nature of the discrimination. Plaintiff is entitled to recover reasonable attorney's fees and requests injunctive relief, punitive damages, attorney's fees, and all other costs. Very interesting. So, interesting intersection of two legal situations in our country. Yes, we want to prevent age discrimination. Yes, we want to prevent gun violence. Can you prevent gun violence by discriminating against someone's age? I'm not sure. I'd want to see the statistics, and I'd want to hear from an actual professional, and I'd want to hear about actual research that was conducted. So before all that happens, Walmart and Dick's have gone ahead and restricted the sale only for certain people. They didn't stop selling things altogether. They just stopped selling them to certain people based on their age. It's interesting. I personally don't like age discrimination stuff. I don't like it a lot. I feel age discrimination from time to time, and I think it's one of the hardest things to try and prove. It's one of the hardest things to try and overcome too, because once you're old, you're old. At least he'll be getting older a little bit, but what if he wasn't? Like what if he was dying of cancer or something, and he wants to go buy a rifle, before he dies or whatever. Perfectly legit thing to do, and he wouldn't be able to do that, and then he wouldn't be able to buy a Now, obviously, he can go buy a rifle from somebody else, but the statute does say that you can't discriminate, so they are in violation, and he has the right to sue. So there's an opportunity for him to make a change to the law and enforce the law as written. He's not even enforcing gun rights, he's enforcing age discrimination statutes. It just so happens that when we have a First Amendment, when we have a Second Amendment, you can't discriminate as to who you give those things to. You can't say all Christians, or you can't say all white people, or you can't say everyone under, everyone over 18 can have it, but stores can decide if they want to sell to people under 21. That's not the way the law is written, and that's not the way the anti-discrimination statute was written, so it was a bit premature for companies to start discriminating against people based on age just because they're concerned about a safety issue that has not yet been addressed by the legislature in their area. So I understand both sides of it. I kind of see both sides of it. They want to take action. They want something to be done about the gun problem. I get it. Like many things with the gun problem, though, people seem to take action quickly without thinking and without consideration for the actual consequences to the law-abiding citizens who are doing their very best to stay in 100% compliance with the law, including its spirit. So it's just really premature for people to start saying no one should have guns because an insane person can get a gun and through government inaction they can do damage with it. I'm sure that doesn't always involve government inaction either. I'm sure that it's possible for an insane person to eventually get a gun, and eventually this will happen again. And it has to be a conversation. There has to be, if not a solution, there has to be progress made. But how can there be progress made when everything being done is hyperbolic on both sides? That's not going to result in anyone meeting in the middle. It really, really, really does feel like William Wallace in Braveheart, and you've got these huge armies on both sides, and no one wants to come into the middle. The only place where that analogy breaks down is if we actually had a conversation about it. We wouldn't have to have the middle ground be warring ground. It would be actual progress. But since nobody's coming into the middle ground to talk, it just ends up with everybody standing on their sides, on their respective sides, turning around and giving each other the moon. Excuse me. Thoughts, questions, comments, concerns?
Question from Callie Lou. If the case does succeed in what they're trying to do, could someone bring a lawsuit to lower the drinking age from 21 to 18? I mean, obviously, those are two completely separate things, right?
Yeah, you may be mistaking things. The reason this has happened is that there is a law saying no age discrimination and a law saying the age of 18 for rifles. The reason why this doesn't apply to the drinking age is that there is a law saying the drinking age is 21. So the Oregon State Legislature could solve this situation very quickly by simply increasing the age to buy guns and rifles to 21. There might be another lawsuit or something, but it would have to be on a different discrimination thing because the state legislature is allowed to say that guns and gun safety can be regulated and raise the age to 21. Or maybe they're not. I mean, somebody could take it all the way to the Supreme Court and maybe somebody will get a ruling. But for now, the solution for Oregon would be to raise the actual buying age of the rifles to 21. The reason why it's age discrimination is because Walmart and Dick's are not the government and don't have authorization from the government through a law. They did it separately. If you switched up this scenario and it was Denny's not wanting to serve anyone over 65 because they don't spend a lot of money, same problem. Same statute, exact same facts. If my grandma's deceased, but if your grandma walks into Denny's at 70 years old and they say, sorry, ma'am, we don't serve anyone over 65, that's exactly the same scenario. This man walked into Walmart, and regardless of whether he was purchasing a gun or not, they said, we don't serve you, you're under 21 years old. That's what's illegal about this. If the purchasing age for a rifle was 21 years old, then they could just say, we have to abide by the law. So in order to get the drinking age changed, you have to appeal to your state legislature and have them change it. So opposite sides of a similar of the same coin, but in this case, they are actually different scenarios.
And back to the drinking stuff really quick. The reason why most states have a 21-year-old drinking age is not because it's a national or federal law, but because 10% of highway funds are actually contingent on the fact that states have a 21 drinking age.
They lose federal highway funds. They lose federal funding for highways and infrastructure, and 10% of the funding is a lot. It's a lot of money.
Yeah. So, I mean, in theory, a state could have a drinking age of 18. But, yeah, they would lose a lot of money.
They would have to defy the federal government.
Exactly.
And here's the other thing. Let me speak ever so slightly practically from the political aspect. I don't mean this as a statement on politics, but this is a real factual thing. Many of the states that would be apt to challenge a 21-year-old drinking age by lowering it to 18, in my opinion, would probably be the redder states. I don't honestly see the bluer states as thinking that it's okay to lower the drinking age. And the redder states are generally the states that receive more federal funds, not less. So I'm really not trying to be political about this. But I would expect that you'd run into a secondary problem changing the drinking age, in that the states that would lose federal funding for changing the drinking age are the ones that use federal funding more than you think they do, or more than other states. So it could be a difficult obstacle to overcome, is what I'm saying. All right, what do we think of that story?
Well,
Yeah, right.
I have a very, I'm pro-gun, but I'm also I don't want to get political, but it's like a mixture of the two, so...
Well, there's believe it or not, there's a lot of us, and it's only when we're in that William Wallace hyperbolic warring situation where so many people refuse to walk into the middle ground. If I say I'm a Second Amendment Democrat, I have not made it easy for everyone to like me. I've in fact made it easy for everyone to hate me. The people who are against guns are like, why the hell are you for guns? The people who are against Democrats are like, why the hell are you a Democrat? So,
yeah.
And so it's not, being in the center turns out to be a double-edged sword, not a safe center.
Yeah, you're not winning any friends by saying you're a centrist,
Yeah. I shoot competitively, and I also carry a handgun for self-protection because I have had my life threatened, and I also don't think you have to have your life threatened to feel the need for protection. But in my state, fortunately, my local law enforcement does not have the right to tell me that I don't need protection. So I do carry a gun, never had an incident. I always stay trained. I stay competent with my equipment. I don't do the gung-ho, tactical stuff. Guns are not cool. I don't want to shoot somebody. I don't look forward to someone breaking into my home so I can shoot them or anything like that. I have been in altercations with people where I have been armed, and I have every single time chosen not to withdraw or use or refer to in any way the firearm. So these are normal things. It's perfectly possible to be a lawful gun carrying citizen. I don't expect the police to be able to save me in just about most situations that I would need a gun. So I'm a scrawny guy. I'm tall. That I have that advantage for me. But I'm a scrawny guy. I'm not terribly strong in like the buff and gonna defend myself. I'm a lightweight. I'm 176 pounds, so it's not like I'm gonna defend myself from a 250-pound person easily. I probably have a better chance of outrunning them at that point. So yeah, I feel like when Alex Maurer threatens my life, or when someone else on the internet says something weird, yeah, I take it seriously, and while I don't get all bent out of shape about it, I consider it part of my personal duty to protect myself, because I have not found the police to be in any hurry to protect me. I don't know why. I'm not sure if it's part of the disposable men problem or something else, but I have definitely not found the police to be in any hurry to come and save me from anything when I call. And I don't call often, and I only call for important things. So that's the end of that rant. You're going to throw a cream pie at me, Mr. Lint. Why? Oh, also for the record, I'm not a member of the NRA. I do not agree with the NRA's politics, and I do believe that we should be having a meet-in-the-middle compromise talk about what is the best response to the school shooting problem. Obviously, we have a lot of school shootings in America. We don't have them elsewhere. It can't just be the guns. It could be partially guns, but I don't think it's just the guns. My opinion, though.
And it's just too entrenched in American history and public belief to get rid of them. Like the solution that a lot of the Europeans offered to our problems is ban guns. Sorry, but that's not going to happen. Like, it's a founding principle that people should be allowed to own guns in our country. It's just not politically possible to do that, you know?
Yeah. Tim of the East has a good point. Police do not have a legal duty to save you, and this is true. This is Warren versus District of Columbia, is a real case. It really happened. It went all the way up to the Supreme Court of the whole country, the whole Supreme Court, and it was found that the police do not have an affirmative duty to protect you if you call and they don't respond at all, or if you call and they respond inadequately, or if you call and they respond late, and you are hurt or injured or shot, and it is 100% clear that if they had simply responded, you would not have been hurt or shot or raped or killed. You still have no claim against the police. Now, does that mean that it's a good idea for police departments not to respond? No, but it does mean that they can pick and choose, and you don't have a legal remedy. I'm not even being extreme here. You don't have a legal remedy at all. You can go and complain to your local city council. That's your legal remedy. Is you can go and complain to your local city council, and you can complain to your police department that they didn't respond. But if you yourself or your family member or your dog or your property is mutilated, assaulted, raped, burned, whatever, and the police don't do anything about it, your problem. And I've had that happen. I was assaulted a few years ago. Someone attacked me in my home. I had stupidly asked them to turn down their music. This is not something I do often. It really was loud music. My whole house was shaking. It scared the heck out of my dogs. I live in a city. It's loud. There's lots of loud music. There's lots of people with loud car stereos. I really put up with a lot of stuff. No problem. This was literally shaking my house. Someone must have installed like the biggest subwoofer in a car that I've ever heard, and it was literally shaking my house. And I admit, I angrily stormed outside. I was like, "What the hell are you doing? Turn your fucking music down." They chased me into my house, broke my window, and tried to beat me up. And the only reason I was able to get them to go away was I ran to my place where I keep my gun, and I drew my gun and I ran back as they were entering my house and pointed it at them. I didn't even have to pull the trigger. I just pointed it at them and they ran. They broke my window, which I was sort of traumatized by it. I still haven't repaired the window. I just put up like a board, and they took off, and I called the police, and I gave the police the license plate number of the vehicle that they were driving, and the police refused to look up the license plate number and charge them. So that's just one of several stories I have, and I don't really want to go into great detail. I have the entire incident on camera, and I don't want to post the video either. Not because it is terrible video, but because I just think it's not going to promote a conversation, and instead it'll make me a target for crap. But that's my story. Like, that's why one of the reasons I carry a gun is I had that situation. I deterred people by pointing my gun at an actual person trying to break into my house. Fizz actually had already broken into my house and was getting through the secondary door to get into my house and was trying to get at me to hurt me. So this hurt was going to be done by 3 people who had already thrown a brick at me. So they were not trying to... This was a life-threatening event. And I only pulled a weapon when there was a life-threatening thing happening. Didn't come out the door with a gun or anything to ask them to turn down their music. It was only after I had a brick thrown at me and my front door broken and people came inside that I pointed my gun. And it made them leave, and the police wouldn't prosecute. They called it vandalism. They said that I deserved the response that I got for having been so stupid to go out and ask them to turn their music down, and they did not look up the license plate number. I called the sergeant on duty and I begged him to look it up, and he refused as well, telling me that it was only vandalism and that there were higher priorities for police than to look up a license plate number and provide an identity to a victim so that that person could be prosecuted. So thank you very much, City of Allentown, for defending your favorite copyright attorney. By the way, this is the same city whose mayor was just convicted under 47 counts of bribery and conspiracy to commit bribery. So, my corrupt city, everyone. Sorry, I got a little ranty there.
That's okay. We have a...
Why am I ranting this morning? I'm so sorry.
We've broken the demon barrier. Luckily, that's not going on YouTube, so...
Well, actually, I've been posting them as unlisted VODs, and they've been monetized, so we'll see if this one stays monetized or not. We were talking about boobs before, too, so it's probably worse than talking about my corrupt city. The gun violence is definitely probably the one that'll get demonetized, too.
Yeah. Oh, yeah, you know what? I'm not even going to defend that. Chicago politics is pretty bad.
Bribed by car stereo manufacturers confirmed. I'm assuming, Kate, you mean the police were bribed by the car stereo manufacturers.
And not you.
The other thing that entered my mind is they were driving a Land Rover, and they didn't look like they were poor kids. So I'm wondering if the police did look up the license plate number, and they decided, we don't want to deal with this. We don't want to deal with this person, whoever they found, whatever it is, wealthy or powerful or something. They found somebody and they were like, we don't want to deal with this. Not worth it. Wish they would just tell me that, though. I could accept that. If they said, look, this is going to be a difficult one because of who this person is, that'd be fine. I would have accepted that. I was perfectly fine suing somebody civilly. And really all I wanted to do was just make a point of like, don't break my fucking window. But, sorry. Got a little worked up there. Don't mean to curse. Okay.
I think we're going to get angry emails about that one.
About what?
It's not important. Anyway, what's the next story on our agenda?
Yeah, one sec. Let me black myself so I can scratch my nose without everybody seeing it on camera. Thank you. This next story is kind of interesting if you're familiar with the way law schools work. The Law School Admission Council has been found in contempt of court. Now, contempt of court means that they already had a court order. So they're in contempt of a court order for violating a consent decree. Another term. A consent decree would be a court order that the parties agreed to. They talked to the judge, and instead of the judge having to issue an order that could be challenged by appeal or something, the parties agreed to an order, and therefore it extinguishes appeal and allows the case to move on. So they violated a consent decree establishing procedures to handle requests for disability accommodations for the law school admissions test. They had been sanctioned in 2014 for not accommodating people with disabilities, and the consent decree required them to stop flagging test scores of disabled test takers who required extra time. The flag would then allow a scorer, a test answer examiner, to evaluate someone, including the information that they requested more time, even though they requested more time only because of a disability. The LSAC violated the requirements instituted by a best practices panel. The problem stemmed from the LSAC's use of what they called 50% emails beginning in February 2016. The emails told people who were seeking a disability accommodation that the LSAC was ready to approve only a partial accommodation. The emails said the accommodations sought didn't have the necessary documentation, so they could have two choices: either revise the request or accept the offered accommodation, the partial accommodation. He or she could provide the documents for supporting the additional accommodations, or could choose the compromise accommodation. Some versions of the letter said that the deadline for accommodation requests had passed, so that the decision to provide additional accommodations would mean having to take a later examination. And law school examinations are conducted about every 6 months, so not something you can take quickly. Other emails said a choice had to be made by a particular deadline, some as quickly as 48 hours. When applicants accepted the offer of a partial accommodation, the admissions counsel would report the request as granted in full on reports required by the consent order or consent decree. The LSAC would use whiteout to replace the initial request with a modified request. When the applicants didn't respond to the email, the LSAC would provide no accommodation and list the request as no decision for insufficient documentation. The 50% emails are no longer used, but that doesn't excuse the LSAC from contempt, nor does its compliance with other terms of the decree. The LSAC said, while this ruling is not the outcome we had hoped for, the Council will continue to work steadfastly to comply with the decree under the guidance provided by the Court's ruling. The Council said it had already adjusted its process after concerns were raised, but the Court unfortunately didn't credit the adjustments or the LSAC's good faith interpretations of the decree, according to the LSAC. So, wow, that sucks. That sucks. If you're a person with a disability, don't you already have a disability? And now you've got to be further disadvantaged by your own damn admissions counsel administering the bar exam? Or excuse me, the law school aptitude test, not the bar exam. It sucks that they would be so disadvantaged by the council administering their own exam. I mean, you want the exam to be fair, but part of the fairness is accommodating people who have disabilities with a fair accommodation. Jeez. I have a fun one here. Can't share this with you. Oh, yeah, then I shouldn't put that in Firefox or I'll get in trouble. I can't share the article with you. It's a private article, but I can share the facts. Facts are not copyrightable. The United States Patent and Trademark Office insisted in an en banc panel. En banc is, I think, everybody, right? It's the whole panel. Of the whole Federal Circuit Appellate Court. The U.S. Patent Office asserted that it was well within its rights in 2015 when it began charging all legal costs associated with patent denials in federal court to the patent applicant. An 1839 law passes all expenses of patent applicants bringing challenges to district courts de novo, which is brand new. Those challenges, win, lose, or draw, the expenses are to go to the patent office paid by the patent applicant. But this new interpretation says that all attorney's fees count as all expenses. Until about 1970-something, or is it in 2015? I guess it was in 2015. Yeah, in 2015 is when it made the sudden change over to charging all expenses to the patent applicant. The U.S. Patent Office has been allowed to pass on expenses regardless of who wins to all applicants denied a patent who pursue de novo district court appeals. A divided Federal Circuit panel agreed in June 2017 that those expenses did include attorney's fees, but the full appeals court vacated the decision in August and agreed to rehear the case together en banc. There was a delay in one case that cost the company $80,000 just because of a delay. And that's very interesting. I don't want to go too much further into their analysis because that's their copyrighted work. So we'll just talk about it for a moment. It's a violation of traditional American legal justice principles that the loser doesn't pay automatically. This is a legal principle. This is something that can be discussed, and we refer to this, generally speaking, as the American rule versus the English rule, I believe. And the American rule is that the parties pay their respective costs of litigation, and that they need to find some other justification for charging the losing party with the costs of the lawsuit. In copyright law, we don't deal with this as often because we have a law, 17 U.S.C. 505, which allows a judge, it gives a judge specific permission. It's not a shall grant, but it's a may grant a request for attorney's fees and costs. So a statute is in place, and therefore the copyright law is covered. But generally speaking, if you sue someone, you don't have to pay their costs if you lose, and that allows trolls to sue people, hope that they win, and if they win a significant number of times, that pays for all the losses. So that's a copyright trolling scheme, or just patent or lawsuit trolling scheme in general, would be just hoping that people would pay up instead of going to court. So the fact that the USPTO doesn't have to pay their own fees means that they have no incentive to minimize their costs. And if they have no incentive to minimize their costs, then that means that they can use that as leverage against the litigation, which gives the government unfair leverage, I would say, against legitimate claimants, potentially legitimate claimants. But again, I'm not a patent attorney. You could talk to one. Maybe Blackleaf would like to add his comments. Let's see what we think about Nantquest versus Iancu. That's the case. I don't think I pronounced that correctly, but we're close.
En banc, I did some research, means in bench. I think it's a more important type of hearing because it's every single judge in the branch rather than a selected panel of judges.
Yes. They are usually the most important cases, the most complicated cases, or sometimes the most controversial cases where a judge doesn't want to be the only one making a decision. You know, like, I only use firing line as a metaphor. One of the reasons we have firing lines instead of just individuals shooting somebody is because we don't, most first world civilized societies and most people in them don't want to shoot a person. So one of the things they do for an actual firing line is not everybody gets a live bullet, and the shooters don't know who is firing an actual lethal round, so that they can all say, you know, this is a randomized thing, and I don't know that I'm the one killing the person or whatever. I don't know how true that is, but that's been told to me by multiple sources, that the firing lines are not always where every single person gets a bullet. We don't do that anymore because that's kind of cruel. And we can murder people under the death penalty rules much more humanely. Even then, it still turns out to be more costly to do that, so I'm not sure why we do that. But that's more of a philosophical existential question than it is a lawful masses question. Or maybe it's a separate lawful masses question. Questions, thoughts, comments, concerns. Did I miss something? I missed something, didn't I? I thought I skipped some. I didn't skip anything yet. No, it's coming up. You know what I'm going to have to skip, though? I think we're going to have to skip the couple, the one that the tactical.
Yeah, actually, I do have an update from her. She says that she can probably condense it, but she thinks it'd be better for a separate video.
Oh, great. That was an excellent conclusion for us to both reach at the same time. That was a most excellent conclusion. Because I really want to go on to this story.
Absolutely.
So we've had a lot of attention over the Pepe the Frog story. I wanted to address some of your concerns and comments about... Oh, wait, I did it wrong. Shit, I pressed the wrong button. Do this again. So we've had a lot of questions, comments, and concerns about the Pepe the Frog story. I wanted to address some of your concerns, specifically your comments and questions on the Pepe the Frog versus Alex Jones video. If one of my staff could post... Well, actually, no, you don't have to do that, because I can do that real quick here. One of my staff could post a link. That'd be great. I'll be the staff member. You did comment on that video. You commented over 400 times. I think we're up to 700. I'll just start over. You did comment on that video. You commented almost over 700 times on that video. Thanks to everyone. Especially to Joseph Stott, who honestly thought that I was going to make out with my dog. To recap, Matt Fury, the creator of Pepe the Frog, is suing Alex Jones, host of InfoWars, because Alex is selling a poster on his website that includes an image of Pepe. So far, the most frequent questions were regarding selectively enforcing copyright or whether that undermines Matt Fury's copyright. After all, Matt Fury didn't sue everyone who created Pepe memes or reposted images. People were asking questions like, at what point does it become public use because they've not challenged it? Didn't they lose their rights to claim copyright when they allowed all those cases? His frog has been used for so long and broadly without complaint that now he thinks he can sue for it. Matt Fury should sue all the people that have made memes over the years, etc. The trouble with this is that copyright is perfectly allowed to be selectively enforced. It's not like trademark where it gets diluted if you don't enforce it, or it becomes genericided if you don't properly license it, or vice versa. I think I got those mixed up. But copyright can be selectively enforced. You can allow infringements of your work to go unpunished, and you can selectively choose to punish or punishment is not a good word, because this is, in copyright infringement, we're always going to be referred to this as compensation or restitution. It's not punishment, but you can always seek compensation or a claim for whichever work you choose. So in this case, he didn't like his works being used in a political way by the alt-right. But it is true, he has said in the past that it is okay to use Pepe. So how does this work? Well, let's go over this interview real quick. I am not going over this interview so that you don't have to go read this article. Someone please go read this article if you want to. I'm posting it in the chat. But what I am here for is the interview. Matt Fury says that his Pepe philosophy is the feels-good man philosophy. It is based on the meaning of the word Pepe, to go Pepe. I find complete joy in physically, emotionally, and spiritually serving Pepe and his friends through comics. Was the comic commissioned? Seeing the frog always takes my breath away and brings a genuine smile to my face. That is what I want every reader to experience every time they think about the Boys Club comic. Thoughts about Pepe becoming a mascot for 4chan? Pepe offers you complete support, attention, and embraces how capable you are of birthing your own Pepe. As your god, my hope is to enhance your Pepe birthing experience by empowering you through it. Obey Pepe. Obey me. Bow down to your leader. Worship me. Give me genital love or non-genital love. Both are wonderful. But 4chan went crazy for Pepe, yes? I believe the most important thing I can do as an artist is protect the voices of anonymous people on the internet and help ensure that those voices are honored. It is my job to help 4chan have the experience that they want without judgment or criticism. What about people profiting off of Pepe? I believe in supporting people's decisions to profit off Pepe in order to provide them with the most excuse me, dying over here. I believe in supporting people's decisions to profit off Pepe in order to provide them with the most positive business experience possible. I strive to be an advocate for Pepe in both love and enterprise, and hope to help business people to have an empowering and joyful experience while making an ocean of profits as limitless as the universe. Pepe is now immortal on the internet. Having Pepe is one of the most life-changing experiences I will ever have. While many may fear the frog, there is no need for anxiety, especially when you feel confident and supported by the 4chan community. This is something my body was created to do, and I did it. So never mind the, tremendous 4chan snarkiness there and obvious wit of Matt Fury. He does appear to tell people it's okay to profit off of Pepe, so what the heck is this about that he's now suing people? Well, this is another part of copyright law. You can revoke your license at any time. Sorry, my earpiece is bothering my ear. These things stay in for a while and they start to hurt. In copyright law, you are allowed to revoke your license at any time, and so that means that if he now says no more Pepe for these purposes, he's allowed to do that. We saw this last year. Which case was it? Crap, I forget. We saw this last year with one of the cases we reviewed. I believe it was a take. Somebody, Brandon, can you remind me? It was a takedown of something.
It was PewDiePie's Firewatch. It wasn't a case.
Firewatch, right? Statement. Right, it wasn't a case. So we saw this last year with Firewatch when PewDiePie had said the N-word on an unrelated PUBG stream, and so the Firewatch developers, completely separately, went and took down or threatened to take down his Firewatch review because that was what they could do to make a statement against PewDiePie's use of the N-word. And I made a video, and Ryan Morrison, the video game attorney, made a statement, and we seemed to be at odds, but we were really on the same side of the thing. What it is you can't revoke the license to stuff that was created under that license, but we can revoke the license as to stuff going forward. So the Pepe poster could be under the revoked license. The Pepe poster might not be under any license. Does this license that 4chan people can create Pepes and profit off of them, does this license saying that people can profit off of Pepe, does that mean you have a license, or does it just mean that a license is available? So these are all things that would have to be answered in the Alex Jones, InfoWars, Matt Fury, Pepe lawsuit before we can really continue to have a productive conversation about the status of Pepe. But suffice to say, for now, until this is resolved, you can probably still create all the Pepes you want as long as you aren't using him as an alt-right meme, and even then, probably not as long as you aren't profiting off of it. But that's not my advice, that's just a guess. Matt is probably going after Alex Jones and InfoWars because of their large organization status, millions of dollars a year in budget, and probably lots and lots of profits to go after. So one of the other things about copyright law that comes into this is that I don't know that the copyright on Pepe was filed in a timely fashion, which means that copyright damages will be limited to actual damages. But even then, if he was able to get statutory damages, the statutory damages might still be a lot less than the actual damages. So we're probably going to see an actual damage claim in this case. It is a bit of politics, but I don't consider it politics when you don't want your art used by a political machine. So is it my politics if I don't want President Trump to use Lawful masses? I don't think so. I think that's me being able to decide how I want my art used. I don't think that's me being political. If President Trump wants to use my stuff for something political, that's President Trump being political, not me, in my humble opinion. But reasonable people can disagree.
You actually have a Grumpy Cat hat in the background as well, which is interesting. I'm sure that one's perfectly licensed, though, right?
Well, see, that's the thing. I don't know that I need to license everything that's in the background of my studio. I'm not selling you a Grumpy Cat hat. I'm not saying I represent Grumpy Cat. I'm not misrepresenting the source of goods or anything. I am decorating. I'm allowed to use decorations. I don't see a problem with putting up a Coca-Cola sign or a Grumpy Cat hat. If I was to put it there in a way that implies that they are sponsoring me or something like that, yeah, that's probably too far. I am not sponsored by Grumpy Cat. I just like Grumpy Cat.
Grumpy Cat is cool.
So then other questions are asking, what about fair use? What about derivative works? Well, this wouldn't be a fair use in my humble opinion, for a couple reasons, but let's go over it. So there are 4 factors to fair use, one of which is the purpose and character of the use. In this case, Alex Jones is selling a poster with Pepe on it for commercial gain and for spreading his political message, which is also some kind of gain for him. So it's definitely for commercial gain. So that's not in favor of fair use. Let's look at the market usurpation section. Who sells Pepe? Well, Matt Fury sells Pepe. He probably sells Pepe dolls and things like that, and Pepe merchandise. He testified to that or evinced that in his complaint against Alex Jones. So he has a market. Are images on posters of Pepe the kind of thing where you would normally license that? Yes, you would normally license someone's art to use on your poster. Is the inclusion of Pepe's likeness in a larger poster of fair use? Well, you'd have to look at it. How much of Pepe was used? Pretty much all of Pepe was used. They got his whole head in there. Pepe is more famous for his head than he is for his body, so I'm going to say that weighs a little bit more in favor of his head being the core part of Pepe that people look at. The image is the shape of Pepe. It looks like Pepe. It's purported to be Pepe. It's not, no one is being secret about it's not a generic drawing of a frog that just happens to look a little bit like Pepe, and nobody was ever trying to connect Pepe to it. They're literally are saying it's Pepe the Frog. So there's no issue proving that that's Pepe the Frog. So does it usurp his market? Absolutely. Is it transformative? Well, yeah, sure. It's arguably transformative in that the poster is a new copyrightable work, but that they've used his copyright in it. Transformation is just the first factor, and it does not automatically outweigh any of the other 3 factors. And so with the other 3 factors, in my mind, going against fair use, and the first factor maybe being a middle ground kind of thing, or like not going in either direction because it is kind of transformative, but it's also it's also just a regular old copy of Pepe. It's not like they did anything new to Pepe. It's the same Pepe, he's just in a poster. So it's not like they took Pepe and did something to make it a different thing. They didn't make their own Pepe. It wasn't a unicorn Pepe. It wasn't a lineman Pepe. It was just a regular generic Pepe. And so, to me, that's not that terribly transformative. And so, honestly, not a fair use. I get that people like to have mascots and stuff, but create your own mascot. Why would you go and appropriate somebody else's mascot? If they tried to appropriate Tony the Tiger as an alt-right symbol, you can bet that Kellogg's would have the right to go after them. It's the same thing. Just because it's Matt Fury and just because he disagrees with the politics of the alt-right doesn't mean that it's any different than any other situation. And this is one of the problems I keep running into when I watch and listen to news about the, generally speaking, the people that are reported as alt-righters, which I realize is kind of a weird Venn diagram of things being conglomerated together there. But it's a lack of skepticism and a lack of critical thinking. The skepticism to say, you know, okay, let's look at how this applies to everybody. Let's look at how it applies to me. Let's look at how different it applies between me and everybody. And then the critical thinking to change one's belief to accommodate reality. I see that as being particularly lacking in that particular stereotype of people. If they can successfully be grouped together, I'm not entirely sure. But there is definitely a movement of some loosely organized group of people who don't seem to like facts and law and like to pick and choose and not apply things evenly to everybody. So why they would feel that it was okay to just go and use Pepe without paying a licensing fee or obtaining permission, or not using Pepe if they didn't, I don't know. We'll see. Maybe there will be some novel theory here, or maybe there will be some evidence that there was a license that applies and that I'm wrong. Who knows? I'm a humble human being. I can be wrong and adjust my beliefs and I can even adjust my day-to-day to accommodate new information. It's amazing. You should try it sometime. I do it every day when I cross the road. If there's a car coming, I stop. I started off by not forming an expectation that I'll be able to cross the road without any traffic, and then I adjusted my behavior by stopping so that I didn't get hit by said car. Sorry if I sound like I'm speaking down to certain people. It just feels weird when people try to throw illogic and non-fact at you as argument in a legal case. It's like, if you're gonna make an argument in a legal case, like, look it up, right? Like, you get it? So I'm not talking down to the people who make comments on my YouTube channel, not at all. Those are awesome. That's all. We have this conversation because you're asking questions. I'm talking about the people who are using Pepe and expecting to be able to use someone else's art without compensating them. I just find that to be really weird. But whatever. I have revealed that I am registered as a Democrat. I do consider myself a centrist, and honestly, I am just as scared of people on the extreme left as I am of people on the extreme right. So while this has been a talk about alt-righters, believe me, if there's something called the alt-left or whatever, I'm just as scared of that and just as against that, and I'll speak just as down to that too. There is no panacea of socialism either in this world. There is no ideal human behavior that we can hold people to either. So I'm not again trying to toe any political side here. I'm firmly down the freaking middle. Moderation, center, constitutional rights, and things that are good for people. Including the good ones, the bad ones, you gotta figure out how to minimize the damage, consequences of bad things, and you've got to figure out how to maximize the good things. The ACLU would like you to know that Tuesday was the first day of the Fish versus Kobach voting rights trial. The ACLU and Chris Kobach, Secretary of State of Kansas, squared off over a 2013 Kansas law which requires people to produce citizenship documents, birth certificate or U.S. passport, in order to register to vote. Kansas is one of only 2 states that impose such a requirement, known as Documentary Proof of Citizenship, or DPOC. The ACLU successfully blocked the law in 2016, prevailing in both the Federal District Court in Kansas and the Circuit Court of Appeals for the 10th Circuit. This case is now back before Judge Julie Robinson for trial, the outcome of which will determine whether or not the law is struck down permanently. The ACLU represents the League of Women Voters and individuals disenfranchised by the law, 3 of whom took the stand to share their experiences. In an unusual move, Kobach, who is being sued in his official capacity as Secretary of State, has chosen to represent himself. Kobach and Dale Ho, ACLU's voting rights director, each delivered the opening statements, which set the stage for the week ahead. Now, this is a very interesting story, and I want you to go read it. So I'm going to post it here, but this is not the story that I want to talk about this morning. The story that I want to talk about this morning stems from that, and I think you'll find it very interesting. As soon as I can locate my agenda notes again. There we go. Oh, I can't double-click on links here. There we go. A federal judge has rebuked Kobach. That's not how trials are conducted. A federal judge rebuked Kansas Secretary of State Chris Kobach Thursday after his team tried to introduce data that has not been shared with opposing counsel at trial. Kobach, Republican candidate for governor, is handling his own defense, along with 2 staff attorneys. The U.S. District Judge has repeatedly warned his team about trying to introduce evidence that has not been shared with plaintiffs during the first 3 days of the high-stakes trial. Kobach complained that the parties in the case are relying on numbers that are stale after the judge blocked a line of questioning. This triggered a rebuke from Robinson. This triggered a rebuke after 3 days of polite warnings on the rules of legal procedure in the face of multiple hiccups from their team. We are not going to have a trial by ambush here. You're stuck with what you provided to them by the deadline. No, that's not how trials. No, that's not how trials are conducted, she told Kobach during the exchange. Sue Baker, an attorney with Kobach's team, tried to interject. Let me finish, the judge said as she continued with her admonishment. Kobach's office had 2 years to update the data on suspended voters being used in the case and waited until the week of trial to try and work in new numbers, Robinson had said. I don't know why I keep calling them Robinson. The trial has moved at a slow pace. The ACLU had hoped to finish presenting by Wednesday afternoon. It was delayed, etc. Spreadsheet that they were trying to introduce showed that 18 non-citizens became registered between 1999 and 2013, a 14-year period. 4 became registered after the order blocking the 2016 law. Doesn't seem to be a huge increase in the people who registered to vote illegally. Only 5 of these people ever voted, and 2 were prosecuted. So, interesting idea if you're a government employee to represent yourself instead of have a law firm or other government lawyer represent you. Good luck. I'm pretty sure the ACLU knows what they're doing. In other news, this is a very interesting case. This is the case where Donald Trump has been accused of blocking Twitter critics. And this is a real quick summary. As soon as I stop hiccuping. Okay. So, Donald Trump last year, or maybe even before that, had started blocking people on his Twitter account. No problem, he wasn't president. Now he's president. If he was conducting official business via an official government account, this would make a little bit more sense. But because he's talking about political stuff, about governmental stuff, using his personal Twitter account, sort of enters a weird realm. It's now a government official, and it's now a governmental communication channel, at least arguably. And when you block people on Twitter, they can no longer see your tweets or reply to them. So they can't even successfully criticize the president's tweets, because when they hit reply, they can't include @RealDonaldTrump in the reply. They can send a tweet and they can type out @RealDonaldTrump, but it will not be notified to people who follow @RealDonaldTrump, and it will not enter Real Donald Trump feeds and things. So it effectively blocks those people from all back and forth public participation of that Twitter account. So Donald Trump was sued. So seven people who were blocked by Mr. Trump were sued, arguing that it is unconstitutional to do so. And they recently had a court hearing where the judge basically said, isn't the answer just mute the person instead of blocking them? And I find this to be just such a really, it's a scalpel. It's such a surgically precise thing to do. I don't know why this hasn't been done automatically already by people on both sides. But if you need to block someone and you don't want to block them in the Twitter sense because it shuts down the conversation, then you mute them. You no longer see them, but the conversation continues without you seeing their tweets. I find this to be a perfectly acceptable way to block people who attack me on Twitter and they don't have anything to add to the conversation. I usually give them about 3 or 4 rounds of back and forth to show me something other than hyperbolic stereotype or something, and then mute. Why block? Then they have a block that they can go show their friends, and they can, complain about how they got under my skin or whatever. Where if I just mute them, then I'm just ignoring them. I'm not adding any energy to the conversation, making anything worse or whatever. So why Real Donald Trump account couldn't just be muting people who are blocked, I don't know. It also sounds like there's going to be a lot of muting going on, a lot of blocking going on. I mean, there was that episode where Butters was required to filter everything out for President Garrison. This feels an awful lot like that. Someone is sitting there every day trying to filter through all the information, trying to keep the stuff that gets under Trump's skin from him so that he doesn't behave like a child as much that day as the day before or whatever. So, and again, this is not my politics. I don't like the president because he acts like a child. And that's an insult to children. I don't like the president because he believes in playing politics instead of transparency. He believes in not caring about the Russian meddling instead of a regular investigation, just a normal investigation into what happened. If he's really not guilty of anything, then who cares? I mean, if the worst he's guilty of is he hired a bunch of people who are guilty, okay, well, let's have it out then. But, 9 Benghazi investigations and all that talk about Hillary Clinton and her emails, and then no respect for the process when it's him who's under the microscope, under the magnifying glass. So that's just my humble opinion on it. But honestly, I would be just as upset at Barack Obama if he acted like this. In fact, I kind of feel like a lot more people would be upset if Barack Obama had acted like this. But whatever. We have an update in the story of the police officer who pulled over an Uber driver and then told him that he was not allowed to be filmed. I'm not going to read the article to you, but just this is... oh, yeah, I've totally screwed that up. Oh, it's over here. Of course. I'm not going to read the article to you, but I am going to show you real quick. This is what we're talking about. This was the, you may remember this one. This was the Uber driver. He was a young lawyer who's driving for Uber, trying to make a little extra money on the side, I guess, and a cop pulled him over, said that he wanted something to do with the passenger, and the cop said that the driver was not allowed to film due to a new law. Turn the recording off or I'll take you to jail. Another deputy confirmed that there was a law that had just passed that prevented the public from recording law enforcement officers. When the Uber driver identified himself as an attorney, saying he knew of no such law that would prevent such an act, he continued to record. He was then counseled after the encounter. The attorney identified himself as an attorney, saying he knew of no law that would prevent such an act, and he continued to record. The deputy was never identified. He was later counseled following the encounter, and then 3 weeks later demoted, which included a pay decrease and a reassignment. Then he appealed. He was reinstated and then resigned. So what happened there, in my humble opinion, was the cop got caught being at least the basics of a corrupt cop. Maybe not the worst kind of corrupt cop, at least not on those facts, but he lied about the law to a citizen, to a law-abiding citizen, to try and trap the citizen in some kind of claim or charge or something. That is really unbecoming of a public servant. And so he was reprimanded for it. And then he was allowed to be reinstated after an appeal and then immediately resign, probably to keep retirement benefits at the previous level. And I wouldn't doubt that there was more than a possibility of a conversation that this is what was going to happen. You know, okay, we'll resolve your appeal by allowing the appeal and then allowing you to resign. You agree to resign and we'll allow the appeal. So that way you get your money. Which I think is just scumbag. I think it's absolutely scumbag. If I went out there and lied to people about the law, I would get disbarred. But a cop goes out there and lies to people about the law and he gets a hefty retirement. I find that to be disgusting and just absolutely untenable. My personal opinion. I think we have one final story. Oh yeah, we're not gonna.
Maybe not.
Maybe not. That was a good one to end on. The final story, I'll mention it and I'll post it here. It's not that I can't cover the story. It's just it's a downer. I don't know that I want to. Don't disbarred lawyers get retirements? No, lawyers don't get public retirement accounts, government retirement accounts at all. Lawyers have to contribute their own money to their retirement account, and they don't get a pension or a government-sponsored retirement account. If I want to retire, I have to put the money away myself. The final story is one I'm not going to cover, just because we're over 2 hours into this, and it is a terribly, terribly depressing story. But Florida has finally changed a law that allowed an 11-year-old to be forced to marry her rapist. The law had said that judges had discretion to allow a marriage license to be granted if someone was pregnant and there was the consent of the parents. So that meant that an 11-year-old pregnant girl was forced by her parents to marry the man who had raped her. And this happened a number of other ways too. I was reading the article, and there's a 15-year-old, and there's a 16-year-old, and there's a 17-year-old, etc., etc., etc. So, horrible situation that we're just not gonna. I'm not gonna go over in any more detail here. I hope you can understand that. That makes sense.
Completely understandable.
Do we have any questions, comments, supporter things, or whatever that you'd like to go over?
I don't really have any questions for you. Most of the stuff was already covered in your coverage, or it's just political stuff, and it's not really necessary to go over. Matt Kai, we've played PUBG with him. He just subscribed on Prime for a month. We also
thank you very much. The Twitch Prime subscriptions really help.
Yeah. Octopus4 also subscribed on Prime. So those are the last two updates I have for you on those.
I do have one minor channel update that I meant to get through in the beginning, but somehow I forgot about. we are starting to explore the idea of putting the live stream back on YouTube or something. The second option is keeping the live stream on Twitch and separating out the gaming. The problem is that we spent something like 50 hours gaming the 1 week, and it sort of became apparent that the gaming is not nearly as much of a draw as the live show, as the Sunday live show is. And that maybe there's a bunch of you that don't want to see notifications from when I go play video games. So instead of me arrogantly assuming that you're all just going to filter through my notifications or not, why don't I just have 2 separate channels? And either we do gaming on Twitch and live streams back on YouTube, which I'm concerned about because of demonetization and all that, but whatever. We've sort of found a model that can work. Or we'll do the live stream, the live show on Twitch, but have a separate Twitch gaming channel. And the reason why I'm announcing this, and we're not doing it yet, is a number of you have subscribed, some of you even for 4 or 5 months, and I don't want you to feel like we're going to take your money and then change things. So these changes will not be happening for at least another month or 2, and anyone who has a problem can certainly contact me and we'll work it out. But whatever changes are made, I only want them to be for the better, so I wouldn't want to make changes and you guys are like, why did you do that? So give me some feedback. If you think it would be better that the live stream is under Lawful Masses and the gaming is under Leonard French, or maybe the Lawful, maybe we do it under this channel, and Weagle, my gaming name, is the thing that we play under, for Twitch, whatever. I really enjoy streaming to you. I honestly never thought that I'd make a couple $100 a month game streaming. That's really cool, and I'm really thankful for that. But I don't want to overlap the two too much. At the same time, I do recognize that some of you want to see what I do elsewhere, and that my Twitch channel is the way I show you more of my in real life stuff. We're exploring that. One of the things I've been exploring while you're here, I have a piano. I play the piano. I write music. Sometimes I just play music for fun. So what if I wanted to play my piano on stream? Does that go on the YouTube channel? Does that go on the Twitch channel? Does that go on a separate channel? Would you guys be impressed that I play the piano? Would you guys want to see that? If I did it more than once, would it get old? So like, I'm trying to feel all this out. It's not just gaming. Like if I make an electronics kit, do you want to see me do that on Twitch? Do you want to see me do that on a separate channel? Do you want to see me do that on YouTube? I honestly don't know, and I honestly don't even know that it's fair to saddle you with the question either. So just let's talk. Let's have some feedback.
If I can weigh in for a second, if that's all right with you.
Yeah, you can weigh in.
So we do have affiliate status here on Twitch, and that does give us like the ability to change what our notification says when we go live and stuff like that. So I wonder if like a possible temporary solution would be to like add gaming to the beginning of the go live notification when you go live with games. That way people who receive notifications will be like, okay, this is a game stream, I don't need to watch this, you know? Or something like that, because logistically it makes sense to keep everything on the same channel, but I can also understand why people might not want to, oh, here's another Leonard gaming stream that I'm going to open and then not realize it's a gaming stream.
Imagine if the numbers were bigger. Imagine if we had 100,000 Twitch subscribers who wanted to watch me do the law show, but that every time I went live with a game, we got 15 viewers. That might make it a little more clear what I'm talking about.
Yeah, exactly. Yeah, I mean, that makes sense to me. But that's the thing. I mean, it's consolidated and it sort of works here. So
if I adjust the go live notification with what I'm doing, at least you know. But at the same time, like you're getting an email every time I go live, and then you have to choose which ones you ignore. I don't like that either.
Yeah. So actually, there's a little
like
bit
at least when you go to tested.com or whatever, they do a variety of things, but it's all related. It's creative, technological stuff. If I'm going to be doing something that's not law related, not in any way law related, just have a separate channel for it. I don't know.
So yeah.
But then again, then I wouldn't necessarily be taking advantage of some of the opportunities that having the 95,000 subscribers do afford to do a different kind of video or something. So it definitely, once again, it's back to moderation. Just got to go right down the center and be like, okay, we're going to do a couple videos that go on to the actual 95,000 subscriber channel, and then the majority of like unrelated stuff will probably have to stay off. But we'll see.
I'm seeing a lot of very constructive conversation in the chat. Feel free to join the Discord if you haven't already and talk about it there. We'll be watching. And you can also, if you don't want to do that, or if you want to send a message to Leonard directly, you can send an email to business@lawfulmasses.com, and we'll read it for sure. We read everything that comes into there. So,
where should people send the answer to this week's trivia question?
Did we ask the trivia question?
We have not asked the trivia question. I am going to start a new trivia question format in the spirit of Car Talk. We're going to have a trivia question every week, and instead of announcing a prize ahead of time, because I'm terrible at having prizes ready to announce, we will pick a winner and pick a prize sometime privately during the week out of the pool of all of the correct answers that are submitted by a certain time. What I haven't figured out is when that by a certain time is, and what we should submit the answers to. I don't want the answers to be submitted on stream, because that would be just dumb to make the answers public, and then everybody could just submit them. But I do kind of want them to be submitted before the end of stream.
We could make another sheet on the questions form and then have Cerulean just...
No.
No.
It would have to be, because it has to be private. They can't do it through the Twitch chat interface.
I can make a form for you. I can make a form.
So for now, let's see how many hundreds of you there are, so I know how many I'm going to have to go through. We'll just give you an email address to send answers to.
Yeah.
There's 193 of you, so at most we could receive a couple more than 193 emails. So here's your trivia question. Please do not answer in the chat. Please do not answer publicly in the chat. What is the name of a cylinder whose diameter is equal to its length? I will announce the winner next Sunday from the pool of all correct answers that were submitted before the end of stream. And there will be another few minutes to stream, so you have about 5 minutes to find the answer. Doesn't matter if you looked it up. Oh. You can submit a correct answer. Do not give the answer on stream. If you give the answer on stream, I will remove it.
Do you want them to tweet it at me or something?
Don't tweet it. Don't publicly anything. Email it to business@lawfulmasses is fine.
I can set up a Google
Email the answer with trivia in the subject line. We'll filter based on trivia in the subject line. If you have both trivia in the subject line and the correct answer in the body, in any form, the correct answer, the actual answer, not just a link to it. I don't want to have to click on a million links. But if you actually have the text of the answer in the thing, you will be put into a bot, and the bot will choose by lottery one winner, and you will receive a small prize that will be announced on the next stream. And we will do this every week so that everybody can have a shot at the trivia question. So once again, today's trivia question is, what is the name for a cylinder whose diameter is equal to its length? Thank you very much for participating if you choose to. Any final thoughts or questions before I close things down with my outro? I know that we start to lose people at this point, so I would like to thank all of you who support this channel. This is a supporter-driven channel. We would not really exist without you. YouTube pulled the adpocalypse last year, and our revenues dropped by about 2/3, and so Patreon has become absolutely essential, and your other various forms of support in the form of subscribing to the channels, or using your Twitch Prime subscription, or going to audibletrial.com/lawfulmasses. Those things help us. They help support the channel and help make more law videos. You may have seen that I've been creating more videos for you as the Patreon money has been increasing. This is not some awful plot of mine to grab all of your money. It literally means that your money is being able to support me and I can do less of the other kinds of work that I have to do that take time away from videos, and I can focus more on the videos and less on the stuff that distracts from the videos. So it really is just a matter of getting to a certain budget, and I'll be able to pretty much switch over to full-time production, and you'll get some sort of high-quality law video every day, or at least 4 to 5 times a week. So, that said, I would like to thank my $50 plus supporters for the month of March. You are DJ Gilcrease, John Steele, Gavin Barnard, The Godslain, Evie, Andy, Kyle Mudrak, John H. Anderson, Vera Mintane, and Sean McNamara. Thank you very much. Just in case you're wondering, any $50 plus supporters, the whole thing gets updated the first of every month. So if you've supported for March, that means these people pledged in February and they were charged on March 1st. So that's how you get on the list. If you don't see your name on the list and you were expecting it, you'll be charged, at the next pledge period for the month, and then that's when I pull down the panel and I update it and do a little bit of an automated thing there. I am working on something more. I would like that panel to be a little bit bigger. I'd like it to be a little bit more Internet of Things, and I'd like to have some commands that I can send it to introduce the names and stuff, as well as have some interactive features where if somebody types a certain command or something into chat, it'll put something up on there. I know I just said that I won't let you do that, but for supporters, we're thinking of some kind of reward that might be filtered through something so that no one can, put a big F word or C word or something up on my my panel. But, so we also have a number of $5 plus supporters, and I have asked you for feedback, and I have received your feedback, and you want more tiers in between $5 and $50 with various rewards. And so I'm going through that. Give me another week or two, and I swear we will have that figured out probably before the end of March. We're also going to be offering merchandise and things like that. And some of the supporters, we might offer either a merchandise credit. I don't know. We'll figure out how this works. I'm not promising anything there. We're going to figure it out. And like I said before, you can go to various places to support, patreon.com/ljfrench or sponsors.org/u/law or audibletrial.com/lawfulmasses. If anyone has any questions or suggestions for stories, they're welcome to email business@lawfulmasses.com. And like I said, you can email them as well for the trivia question. You have a few more minutes to do that. I'll officially close the trivia question at the end of the stream when we take it out. So, does anyone have anything else to say? Otherwise, I'll bring in some music and go get some dogs. What do you think?
Do you miss me at all? Do you think about the things we used to do? No, you couldn't stand tall. So why didn't you call? So many years has gone by, but I think about you all the time. Looks like you're changing and all, but why didn't you call? Something in the air, always something in the air. Inexplicable, I can feel it in.
Alright, here we are. Zoom out. Mr. Dog, hello. Oh, you get a treat. You smell good. Were you rolling in that you smell good? Yes. She tried to take his treat out of his mouth. Of course she would. Hi. Hi. How are you? How are you? You having a good day? Is it cold outside? Hello. I'm gonna kiss. Here's a kiss. So, everybody say hi to Nico and his happy friends. What a good boy. So thank you everyone for joining me. I am Leonard French, your favorite copyright attorney, and I will see you in my next video and in the next live show. I love you all. Have a great week. All right, everybody, we're out. Have a great Sunday and a great week. I'll see you in the next one. Bye.